Good morning, everyone, and welcome to the first Radcliffe Chambers Junior Programme Seminar of 2025. My name's Matt Mills, and joining me in the commentary box is Harmish Mehta. Good morning, Harmish.
Morning, Matt. Good morning, everyone. Thanks for joining.
Today, we'll be talking to you about two topical charity law issues. First up, Harmish will tell us about disqualification of charity trustees, and after that, I'll tell us about disposals of charity land. As always, we're very happy to take any questions you might have. If you want to ask us a question, please click on the Q&A button at the bottom of your screen and type your question there. Don't worry, only Harmish and I can see them. Without further ado, I'll hand you over to Harmish.
Thank you very much, Matt. I'll be talking today about disqualification of charity trustees. Disqualification restrains a person from being a charity trustee and, where relevant, from holding a position with senior management functions in a charity, and by imposing criminal and civil sanctions for doing so. A disqualification does not affect the removal of a person from any such position. I will discuss two disqualification regimes. The first regime is automatic disqualification under the Charities Act 2011 at section 178. This disqualification arises once specified criteria such as conviction of a relevant offence are satisfied and takes effect without the exercise of any power. By contrast, the second regime, a discretionary disqualification under the same Act at section 181A, does require the exercise of a power, and that's the exercise of a power by the Charity Commission. I will speed through the first regime in order to focus on the second, but there are related topics that I will not speak about in detail, but ought to be noted. First, a charity's governing document might disqualify a person from holding certain positions. Second, there are rules providing for partial disqualification relating to remuneration. Third, a director disqualification under the Company Directors Disqualification Act 1986. And the slide is slightly inaccurate in that the 1986 Act applies not only to company director disqualification, but disqualification in relation to CIOs, of course. And this regime is, of course, relevant to charitable companies and to CIOs, but it fits best into a talk on companies law. Fourth, there are other regimes, such as the safeguarding regime, which can also restrict a person from holding a position at a charity. To turn to the key sources of law and guidance, the key legislative provisions are contained in Part 9 of the 2011 Act. These provisions were amended substantially by the Charities Protection and Social Investment Act 2016. Where I refer to a statutory provision in this talk, I will mean to refer to the 2011 Act, unless I state otherwise. I will largely be summarising the statutory wording instead of repeating it at you verbatim, but I have to say, as ever, that the wording does need to be consulted for a complete understanding of the law, of course. It's also useful at this stage to list the documents containing the Commission's guidance. As to automatic disqualification, there is the guidance for charities, the guidance for individuals, and the waiver guidance, and the first two of these overlap considerably. As to discretionary disqualification, there is the explanatory statement with the accompanying Q&A. This statement is of particular significance. Also, as to discretionary disqualification, there is the Commission's operational guidance at OG 525. So what is a charity trustee? In this talk, I will use the term charity trustee as an abbreviation for the more long-winded phrase charity trustee or trustee for a charity. And the phrase charity trustees is defined at section 177 of the Act as the persons having the general control and management of the administration of a charity. So, of course, formal titles aren't determinative. And the phrase trustee for a charity is not defined in the Act, but appears to mean a person who is a trustee for a beneficiary, which is itself a charity. What is slightly easier to miss is the provision for corporate decision-making in section 184A. So for the purposes of the disqualification rules, a person who is not a charity trustee or trustee for a charity is treated as one if that person, A, is an officer of a body corporate, which is a charity trustee or trustee for a charity, and B, takes part in that capacity in any decision relating to the administration of the charity. Notably, the term officer includes any person having general control and management of the administration body, again, regardless of the formal title of their role. I'll turn now to automatic disqualification. And by way of overview, there are 11 cases A through K, in which a person is automatically disqualified. For brevity, I will not list them, and the guidance helpfully offers a tabulated version of these cases. It suffices to say that these cases include the person having an unspent conviction for certain offences, being subject to certain insolvency procedures, being disqualified under the 1986 Act, and being subject to certain charities-related measures. Events that occur pre-commencement can give rise to automatic disqualification. And the Commission offers a register that must record all persons removed as a charity trustee by the Commission or the Court. But there is no unified or complete register of all persons subject to automatic disqualification. So charities do need adequate measures to identify disqualified persons. The guidance for charities does suggest that charities ask relevant persons to sign declarations that they are not automatically disqualified, both at the onboarding stage and later at reasonable intervals. And the guidance does offer sample declarations for this purpose. The effect of automatic disqualification is to disqualify a person from being a charity trustee and to disqualify them from holding an office or employment in a charity with senior management functions. A function is a senior management function if A, it relates to the management of the charity and the officer or employee, meaning capital A in this statutory text, is not responsible for it to another officer or employee other than a charity trustee. Or B, it involves control over money and the only officer or employee other than a charity trustee to whom A is responsible for it is a person with senior management functions other than ones involving control over money. And again, the title of the office or employment is not determinative. And to delve into this a little further, the guidance for individuals addresses what the Commission considers to be a senior management function. And the recurring theme there is the closest, most senior person below the charity trustees, being defined as someone with a senior management function. And where the Commission opines in this way on the meaning of the statutory wording, its guidance is, of course, not binding on a court, but it's often persuasive. And if additional aids to construing what is a senior management function are needed, they can be derived from paragraph 66 of the explanatory notice of the 2016 Act and paragraph 77 of the government's consultation paper preceding that Act. A practical point is that caution will be needed where a former charity trustee or senior manager has been automatically disqualified but continues to be involved with the charity in what is intended to be a more junior capacity, as is permitted. But despite such good intentions, there may be a risk of that person being leaned upon because of their previous role and their expertise, and therefore coming within the restriction. The Commission may waive automatic disqualification generally or partially on application by a disqualified person. In cases of disqualification under cases D, E, or I, and these are charities-related cases, the Commission's discretion is constrained. If 5 years or more have passed since the disqualification took effect in such a case, the Commission must grant the waiver unless special circumstances mean that it should be refused. And I can refer to the waiver guidance for a non-exhaustive list of special circumstances. A waiver can't overcome a disqualification arising from the charity's governing document. It can't overcome rules other than the automatic disqualification rules, such as safeguarding rules or disqualification under the 1986 Act. These rules preventing the person's appointment by means other than the automatic disqualification regime. And the waiver guidance details the Commission's decision-making process for waiver applications and does set out helpfully what a waiver application should contain. A decision of the Commission to waive or not to waive may be appealed to the first-tier tribunal by the applicant or by any other person who is or may be affected by the decision. And those entitled to appeal may also request a review by the Commission. Here I can briefly flag the case of Blacker and Charity Commission, in which the tribunal found it useful to consider the case law arising from the regime under which persons disqualified under the 1986 Act seek leave from the court to act, notwithstanding their disqualification. I won't say more about challenging the Commission decisions because to feed your addiction to the Radcliffe Chambers Junior Programme, I can refer you to the talk on this topic given by Natalie Pratt, a fellow member of Chambers. I can turn now to discretionary disqualification. The power is contained in section 181A, and a discretionary order may disqualify a person in relation to all charities or only those charities specified in the order. There's a great deal of latitude given in the Act to the Commission to tailor the order to the circumstances as the Commission sees fit. The prohibitions in respect of senior management functions I've discussed already apply in the same way here, unless the order disapplies them fully or partially. There are three conditions for the exercise of the discretionary power. First, one or more of certain sub-conditions must be met in relation to the person who is to be disqualified. Second, the person must be unfit to be a charity trustee, either generally or in relation to specified charities. And the third is that making the order must be desirable in the public interest in order to protect public trust and confidence in charities generally or in specified charities. I can turn to the sub-conditions which form the first of the primary conditions. And the sub-conditions in subsection 7 of 181A are as follows in very brief summary. Subcondition A, caution for an offence in case A against a charity or involving the administration of a charity. And by case A, I mean case A for the purposes of automatic disqualification. Subcondition B, conviction under foreign law of an offence against a charity or involving the administration of a charity, which would fall into case A if it were committed in the UK. Subcondition B, being found by HMRC not to be a fit and proper person to be a manager of a body or trust. Subconditions D to E are in essence responsibility for or complicity in misconduct or mismanagement in the administration of a charity. D is where one has been a trustee or has held analogous roles in relation to a charity. And subcondition E is about where the relevant person has been an officer or employee of a corporate trustee. Summary. And subcondition F is that any other past or continuing conduct by the person, whether or not in relation to a charity, is damaging or likely to be damaging to public trust and confidence in charities generally, or in those specified in the order. There are some additional points to be made as to the subconditions. Under subconditions A to B, or in relation to those subconditions, there are subsections 10 to 11 of 181A, which provide that those subconditions apply whether the caution or conviction occurred before or after the commencement of section 181. But subcondition B, unsurprisingly, provides that it does not apply in relation to a conviction which is spent under the law of the country or territory concerned. And in relation to that, subsection 12 contains definitions assisting with the references to foreign law in subcondition B. The subconditions D to F are particularly open-textured, and the explanatory statement contains a substantial amount of guidance as to how the Commission approaches them. The Act contains no definition of misconduct and mismanagement. The Tribunal has in the past considered in this context that it's useful to refer to certain case law on these concepts, which arises from the Commission's protective powers. And for these purposes, I can refer you to yet another talk by my colleague Natalie on the topic of protective powers. The case of Nike and Charity Commission is of general interest because of how the Tribunal dealt with various arguments of the appellants and because of the factual background. But for brevity, it suffices here to note what the Tribunal said about subcondition F. The Tribunal did not accept that only conduct that has occurred or been continued after the commencement of section 181A may be taken into account for the purposes of that subcondition. So the Tribunal filled a gap as to provisions about pre-commencement events. The Tribunal did not consider that possible reputational damage to the Charity Commission was the kind of damage contemplated by subcondition F, but it did observe that the expression of offensive or objectionable views by charity trustees can come within the sub-condition. Its position was that such expression does not necessarily pose a risk to public trust and confidence in charities. But for such a risk to arise, as the tribunal considered it, there would need to be some connection between the views in question or the manner in which they were expressed and a particular charity or charities generally. As to the second and third conditions, unfitness and public interest, these are also dealt with extensively in the explanatory statement, but this is an appropriate juncture at which to consider the tribunal's recent judgment on Mond and Charity Commission, which was handed down on the 6th of February. Mond is the first occasion on which the tribunal has quashed a discretionary disqualification order, and Joshua Winfield, a fellow member of Chambers, appeared for the successful appellant. The appellant had held senior positions at several charities. The Commission had ordered disqualification relying on subcondition F and pointing to social media activity, namely 2 comments and 2 likes, which it regarded as anti-Muslim and or Islamophobic. The majority of the tribunal found that subcondition F was satisfied. However, the tribunal concluded that the unfitness condition was not satisfied. It noted the limited scope and profile of the social media activity, the limited connection between the posts and the likes, and the limited connection between the activity on social media and any charity or charities generally. The tribunal also concluded that the public interest condition was not satisfied. It noted again the limited scope of the social media activity. It noted that it was spontaneous activity and noted that the appellant had apologised for it and resigned from his offices when asked to. And throughout its final conclusions, the tribunal stressed its concern not to set the bar for conduct so high that individuals who may be effective trustees would be put off from taking up office. Notably, the arguments of the appellant included arguments relying on the European Convention on Human Rights. The tribunal referred to Article 10, the right to freedom of expression, in its conclusions, albeit without conducting any extensive analysis of that right, such as the proportionality analysis that it would normally attract. Convention rights are of interest here because where they are engaged, they can provide an important additional area or arena of argument in disqualification cases. And this is because Section 6 of the Human Rights Act provides that it is unlawful for a public authority to act in a way which is incompatible with a convention right, a relevant consequence being that it is unlawful for the Commission or Tribunal to make an order as to disqualification that is an unjustified interference of the convention right. Section 3 of the Act also requires public authorities to read and give effect to legislation in a way that is compatible with convention rights. This hasn't been explored extensively in relation to the disqualification provisions, surprisingly. Section 2 of the Act requires a court or tribunal, when determining a question connected to a convention right, to take into account the case law of the European Court of Human Rights. And this is a vast body of case law. This could be significant in the disqualification context, where there is little case law from the first-tier tribunal. And strictly speaking, rulings of the first-tier tribunal do not provide binding precedent, although they are often persuasive and persuasive by default. The tribunal in Mond also stressed that its conclusion was grounded in the facts of the case before it, and that it did not intend to come to any general conclusions about social media use by charity trustees. The period of discretionary disqualification must not be more than 15 years, beginning with the day on which the order takes effect. The period must also be proportionate, having regard in particular to certain circumstances about convictions being spent and circumstances where the Commission may or must grant a waiver. The explanatory statement sets out 3 bands of seriousness that the Commission will use to help determine the period of disqualification. These bands have been adopted by the tribunal in the case of Knight, and the explanatory statement is significant because it is often referred to and considered by the tribunal as part of its analysis. The operational guidance provides that the case officer should, when considering proportionality, have regard to 3 principles: 1, protection of charities and the public; 2, rehabilitation and reintegration of the person into the sector; and 3, deterrence. The procedure relevant to discretionary disqualification can be set out in 7 stages. The first stage is pre-notice. The legislation does not require this stage to take place, but the operational guidance does provide that where there has been no previous engagement with the individual who is to be disqualified, the caseworker must communicate the Commission's concerns to them and seek their comments, and the caseworker must also make reasonable attempts to secure a response. The second stage is notice, and there are three relevant types of notice. First, unless the order is made by consent, the Commission must give the person at least 1 month's notice of its proposals and invite representations. And turning to the other two types of notice, before making an order in respect of a person who the Commission knows or believes to be a charity trustee, the Commission must also give notice of its proposals to each of the charity trustees of the charity in question. That's the second type of notice. And subject to a further provision, it must give public notice inviting representations to be made. And this is the third type of notice, but public notice is not required if the Commission is satisfied that it is not necessary. And public notice may include notices displayed on the charity's premises or in its local area of operation. At the notice stage, the Commission will provide a provisional statement of reasons for the order, which will be finalised when the order is made. The third stage is suspension, and if the first type of notice has been given, the Commission may suspend the person from being a charity trustee or trustee for a charity immediately, and the Commission's policy is to suspend immediately if it considers suspension to be appropriate. There is no legal test in the legislation as to when a suspension order ought to be made, and the Commission has formulated its own criteria and put it in the operational guidance. A suspension order may make provision for enabling any person to execute an instrument in the suspended person's name or otherwise act for that person, and in the case of a suspended charity trustee, for adjusting any rules governing the proceedings of the charity trustees, or to take account of the reduction in the number capable of acting. The suspension may not be for longer than 12 months, but during a suspension, the Commission may extend or further extend the suspension, provided that the order does not extend the suspension for a period of more than 12 months, and the total period of suspension is not more than 2 years. The Commission must review any suspension order at such intervals as it thinks fit. So suspensions can be long-lasting, and the means of forcing the Commission's hand is to appeal the suspension order itself. And I will come to that. The fourth stage is review by the Commission if requested. I've placed this prior to appeal, but of course review may take place after an appeal is initiated. For example, initiating the appeal to be within the timeframes and then stay it for the review to take place. The fifth stage is an appeal to the tribunal against the disqualification order or the suspension order. Only the person who is the subject of the order may appeal, save that a decision to discharge or not discharge a suspension order on review may also be appealed by charity trustees of the charities which the order relates, the charity itself, if it's a body corporate, and any other person who is or may be affected. The sixth stage is the taking effect of the disqualification order. This occurs at the end of the time specified in the rules for starting proceedings for an appeal, which is currently 42 days, and that's if no proceedings are started within that time. Otherwise, if proceedings are started, the disqualification order takes effect, subject to any decision on appeal, when proceedings started are withdrawn or fully determined. And the seventh stage is any variation or discharge of the order on application or on the Commission's own initiative. The Commission will be informed by its approach on waiver for automatic disqualification in decisions on whether to vary or discharge. And a more complex flowchart about the procedure is available in the explanatory notes to the 2016 Act. I can speed through some final points now. As to the civil consequences of acting in breach of either form of disqualification, 2 points fall to be made. First, any acts done as charity trustee are not invalid merely because of the disqualification, though this is subject to the charity's government document. Second, the Commission may order the return to the charity of remuneration, expenses or benefits obtained in connection with acting in breach of the disqualification. And the criminal consequences are that in general acting in breach of a disqualification is an offence subject to one exception in section 183. What I do want to wrap up with is forward planning. A significant practical point relating to disqualification is the advisability of systems being in place prior to disqualification arising. For a charity trustee and the charities they're involved, disqualification is more of a steep drop than it is a gradual descent. And this applies at least to automatic disqualification, which provides no grace period to permit a transition out of the role. And as highlighted in the Commission guidance, forward planning will be needed to include provision to ensure the charity's governance can continue, systems to ensure that disqualified trustees stop acting as trustee, that the Commission is informed if a person refuses to resign or cannot be removed, and that a serious incident report is made if it's discovered someone is acting in breach, and consideration will be needed of employment law consequences of stopping a person from acting in their role. Now, I note in this regard that the guidance for charities suggests that a person who is not yet automatically disqualified, but will be disqualified, can apply for a waiver in advance. This isn't the neatest fit into the statutory wording, but at least a preemptive application for a waiver to be granted is, at least on reasonable grounds, potentially possible. And if it's to be granted immediately once disqualification comes into place, that would fit fairly neatly into the statutory provision. That's the end of my talk. Thanks for listening. I will now hand over to Matt.
This is a talk about charity land. Now, there have been statutory restrictions on the right to sell charity land for 170 years, so why did it take me so long to get around to doing this talk? Well, I think this talk is particularly important now for two main reasons. Firstly, the law and practice is changing. Over the last 18 months, the Charities Act 2022 has amended some of the key restrictions on disposing of charity land. And just last month, the Commission updated its main operational guidance. My second reason is that the consequences of getting this wrong can be severe. Generally, if you breach the rules restricting dispositions of charity land, the disposition is void. That can have very serious consequences, both financially and reputationally, for the charity. There can also be consequences for the individual trustees who breach their duties and may face a claim for compensation or even removal. So that's why it's important. But what are these restrictions? Before we get there, before trustees can consider making a disposition, they must confirm that they have the power to do it. Now, importantly, the provisions in the Charities Acts do not confer a power to sell charity land. Instead, they constrain other powers. So how do you know if you do have the power? Well, I suggest that you look in three main places. First, as always, you should check the governing document. Often, both unincorporated and incorporated charities have express powers to sell and dispose. For example, all of the Charity Commission's model governing documents give trustees a power to sell, lease, or otherwise dispose. But you should also look for restrictions in the governing document. These might be substantive, for example, a rule prohibiting a sale of a particular piece of designated land, or they might be procedural, for example, a requirement to call a public meeting before land can be sold. If the charity that you're dealing with doesn't have an unfettered power to dispose, you may be able to introduce one by simply amending the governing document. But if you can't rely on an express power, you may be able to rely on the general Section 6 of the Trusts of Land and Appointment of Trustees Act 1996. That gives trustees of land all the powers of an absolute owner. Now, this applies regardless of when the charity was created, and it can't be excluded. But it can be subject to certain third-party consents. For example, the holding trustees might be required to consult the charity trustees before they sell any land. Now, there are four important restrictions on this general power. First and foremost, you can only rely on it if the land is held on trust in the strict sense of the word. So, for example, this will not apply to corporate property, which is not held on special trust. The second exception is practical. Although the Charity Commission believes that Section 6 gives you a power to mortgage charity land, some corporate lenders don't agree. And if the lender you're consulting says Section 6 is not enough, you'll need to try and go through the amendment process to create an express power. The third exception is pretty niche. This doesn't apply if the land is governed by the Universities and College Estates Act. The fourth exception, though, is more general. This power is subject to any other enactment or any rule of law or equity. Now, specifically, the reference to enactment includes the restrictions in the Charities Act, and the reference to equity means charity trustees must still act in the best interests of the charity, and they must still respect the distinction between income and permanent endowment. So you can't use Section 6 to get around any of those fundamental duties. In addition to this general power, there are a few specific powers found in certain statutes. For example, if the trustees are liable to pay compensation for improvements to one of their tenants, statute gives them the power to grant a new lease instead of paying that compensation. A second example is that the School Sites Act and the Literary and Scientific Institutions Act allow charity trustees to grant up to 1 acre of land for specific educational, literary, or scientific purposes, as long as you have the Commission's consent. And thirdly, local authorities have the power to sell land, even if it's held on charitable trust, as long as they have the consent of the local parish and the Secretary of State. Lots of these are quite niche, but sometimes they might help you out. What about the common law, though? Well, historically, the position was that charities could dispose of their land even if they didn't have an express power in the governing document, as long as this was in the best interest of the charity. I've put an example quote on the screen, but there are others that we could use. But it's not entirely clear if this line of case law has been superseded by all the legislation that's happened since. So I would caution you against trying to rely on these old cases. Also, practically, you probably won't need to rely on these old cases because it's now usually not too difficult to amend a governing document to create an express power. So you don't need to go digging through the Victorian authorities unless you really have to. So that's your preliminary step, establishing that you have the power to do what you want to do. Once you've got that power, you need to consider the statutory restrictions that are found in Part 7 of the Charities Act 2011. The default rule is set out in section 117. I've put it on the slide. In a nutshell, you can't dispose of charity land unless you've got the consent of the court or the Charity Commission. Now, before I turn to the detail and the exceptions, I want to make 6 preliminary points. Firstly, technically, these sections only apply to selling or disposing of land and not to buying charity land. But best practice in many cases will be to follow a similar process. Secondly, these rules only apply to land in England and Wales. If your charity's land is located elsewhere, technically the rules don't apply, although again, best practice would be to follow them. Thirdly, the default rule only applies if all of the land is held on trust for one charity. If, for example, the charity is one of 4 beneficiaries in a will, section 117 doesn't apply. Fourthly, and relatedly, this default rule doesn't apply to sales by personal representatives, even if all the sale proceeds are going to be passed on to the charity as part of the administration of the estate. Fifthly, this rule is not limited to permanent endowment or functional land. It applies to all land in England and Wales. And sixthly, although, as the quote says, you can get by with an order of the court, litigation will very rarely be the right option. At a minimum, those would probably be charity proceedings, and the Charity Commission would be reticent to give you permission because of the other options available. So in reality, the default rule is the permission of the Commission is required. Now, this section concerns dispositions of charity land. Well, what does that term mean? In a nutshell, it's understood in the same way as it's understood in property law generally. So, for example, the word disposition would include the creation of rights like a sale or a lease, an easement, a way leave, or an option to purchase. It would also cover alterations of rights like surrenders, assignments, extensions of leases, or the release of a restrictive covenant. On the flip side, the following are not dispositions: an uncompleted contract for sale of land, a license or tenancy at will. Remember your law school days? A right of first refusal, which is sometimes called a right of preemption. The granting of a consent by a charity landlord to its tenant for the tenant to do something, maybe make alterations. Surrenders or assignments by a charity's tenant, and a transfer from retiring trustees to new trustees. These things are not caught by dispositions. Now, we've talked about the court briefly, but what about the commission? Now, as I'll go on to explain, the vast majority of dispositions of charity land occur without the input of the Charity Commission. But there are certain situations in which you either want to or need to consult the commission. I'll give you some examples on this page. If the disposition is to a connected person, or the trustees want to sell the property by auction, in which case, in theory, a connected person could bid, or if the costs of going through the alternative process are disproportionate to the value of the land in question. For example, if you want to grant a lease of a very small bit of land for a telecoms mast, or if the transaction is particularly complex for certain reasons, or if the trustees can't find any suitable professional advisors, maybe because the land is particularly remote or particularly unusual. Or if the advisor can't recommend the disposition to the trustees, but the trustees still genuinely believe it's in the best interest of the charity. A final example would be if the trustees want to make a disposition at an undervalue. For example, if they're disposing of land to a local authority on a tacit understanding that the local authority will keep it open for a bit longer. But don't be too ready and gung-ho about contacting the commission. The commission's general policy is that charities should use the alternative process where they can. But if you are going to contact the commission, there is a handy form online. I've put the link on your slide, and the operational guidance explains in detail what the Charity Commission needs to see and what they'll do. But in summary, your application will need to show that the charity trustees have, firstly, the power to do what they want to do, and secondly, they've managed conflicts, dealt with any objections, followed any advice, and overall decided that it's in the best interest of the charity. I should say in practice, the Commission will almost always expect you to have got an independent report as pursuant to the alternative process. So you can't use the Commission as a way of getting around that requirement in most cases. So that's our default rule. I will now talk about the exceptions to it. In other words, when you don't need the consent of the Commission. Now, in practice, the main exception is so widely used that it is in reality the rule. There are two categories of exceptions. The first category is for certain types of disposition, so the nature of the transaction. For example, a lease by a charity to a beneficiary for less than market rent and in furtherance of the charity's purposes. That sounds like a mouthful, but it's pretty self-explanatory. Things like leases of almshouses. A specific example is if a charity is releasing a rent charge for at least 10 times the annual amount the charity receives, you don't need to worry about the default rule. But if you're charging less than 10 times the annual amount, the default rule does apply. The default rule also doesn't apply to advowsons, which is the right to nominate someone for an ecclesiastical office. Pretty niche. And slightly different rules apply to mortgages. I'll talk about them later in this talk. There are broadly similar rules, but technically the general rule in 117 doesn't apply. That's category 1, certain types of dispositions. Category 2 is for dispositions involving certain people. I'll go from niche to broad. If your disposition is authorised by the Secretary of State under the Universities and College Estates Act, you don't need to worry. Or if your charity is an exempt charity, or if the disposition is made by an insolvency practitioner during an insolvency, then you don't need to worry about the default rule. Also, if your disposition is authorised by legislation or by scheme, you don't need to worry. Now, this sounds niche, but it could actually be quite broad. For example, it's probably going to cover things like cooperative and community benefit societies, some compulsory purchase situations, statutory charities, and charities established by church measure. Our fifth exception is for dispositions made to another charity for less than market value. For example, if an unincorporated charity wants to incorporate and transfer all of its assets for nothing to the new incorporated charity. The final and most important exception is for dispositions which are not to connected people and for which the trustees have gone through the alternative procedure. Now, this is by far the most important exception, so I'll explain it in more detail. As you can see from the slide, unconnected persons is the key term. So who is a connected person? Well, it's defined very broadly in the Charities Act, but in a nutshell, the list includes trustees, donors of any land to the charity, regardless of whether it's the land in question, certain close relatives of those people, most officers, agents, and employees of the charities, and the spouses or civil partners of any of those people, and partnerships, institutions, and companies connected with any of the people on the slide. To give you a practical example, a charity's trading subsidiary would be a connected person. If your disposition involves a connected person, the default rule applies: you need the consent of the Charity Commission. But if your disposition is to an unconnected person, you can go through the alternative process, and that's what I'll talk about in section 4. In a nutshell, in most cases, trustees need to do two things. Firstly, obtain and consider a written report from a designated advisor. And secondly, decide that the terms of the disposition are the best that can reasonably be obtained. In a nutshell, take advice and self-certify. I'll start with the second of those points, the decision by the trustees. Ideally, this decision should be taken at a meeting, but it is possible to delegate the consideration of the report to a subcommittee, as long as the trustees still retain overarching management functions and control. The final point to note is the best that can reasonably be obtained doesn't always mean the highest price. It means what it says on the tin, the best you can do in the circumstances. So that's the second part, the easy part, the decision. The more technical part is this written report by a designated advisor. So let's start by talking about who a designated advisor is. In a nutshell, a designated advisor is someone who falls in the following categories: a professional associate or fellow of RICS, a fellow of Property Mark, a member of the Central Association of Agricultural Valuers, or anyone else who the trustees reasonably believe have ability and expertise in valuing relevant land. It is technically possible to instruct a firm, even though the legislation refers to a person, and it is now possible for trustees, officers, or employees of the charity to provide the report internally. But before you see this as an easy way to save money, charities should weigh up, on the one hand, the short-term cost saving of keeping it in-house, and on the other hand, the benefits of external input and professional indemnity insurance. In any situation, this is fundamentally a decision for the charity. The Commission will not pick a designated advisor for you. So once you've found the right person, they need to produce a written report that complies with the new 2023 regulations. Fortunately, these regulations are simpler than the old 1992 regulations. So really, the report needs to cover four main things. It needs to confirm the advisor's qualified and not conflicted. It needs to value the land and describe any ways you could make it more valuable. It needs to discuss whether the land should be put on the market, if it hasn't been. And it should give any other suggestions for making the deal better. Now, technically, trustees are no longer required to advertise the proposed disposition, but if your advisor suggests it, it's usually best practice to do so. Anecdotal evidence suggests that you're looking at probably up to about £2,000 for a report on a simple case under the regulations. And technically, you should obtain that report before the deal is signed, although in theory, the court may still uphold the transaction if you get the report later. So that's our general alternative process. Designated advisors report, best terms that can reasonably be obtained. But there are slight variations to this alternative process. and the first concerns leases. If the lease is for 7 years or less and doesn't involve an upfront lump sum, you don't need advice at all. And technically this applies even if the lease is for 7 years and there's a right to renew for the tenant. It's just the initial term that matters. If your lease is for more than 7 years, or there is an upfront lump sum, then you need to go through a slightly watered down alternative process. Obtain advice from someone the trustees reasonably believe is suitable, and again, decide that the terms are the best that can reasonably be obtained. Although this looks similar to the standard alternative process, technically this sort of advice can be oral. It doesn't have to be in writing, although obviously it's best practice to get written advice if you can. Also, the written report in this case doesn't need to comply with the regulations. It's just advice. And again, although there's no requirement, it's good practice to pick someone from the list of professional bodies, but you don't have to. So for leases, the alternative process is simpler. On the other hand, if you're dealing with designated land, the alternative process is stricter because there's an additional requirement. Now, sometimes a governing document will require the trustees of land to use it for a particular purpose of the charity. For example, it might say that you have to use this house as a museum or as an almshouse. That would be designated land. If the trustees want to dispose of designated land, then in addition to the designated advisor's report and deciding it's the best terms that can reasonably be obtained, there's a third requirement. You need to give notice of the proposed disposition for at least a month and take into account any responses you receive. Now, there is no prescribed content for the notice you need to give, but the Charity Commission gives you very practical suggestions saying you should include details about the charity and the disposition and refer to section 121. There's also no prescribed method of giving notice, but generally you should try and reach as many people as possible in the beneficial area. And you can be practical here. Websites, social media, local newspapers, all the things you would commonly consider. So that's usually the additional requirement for designated land, notice. But there are certain situations in which this additional third requirement doesn't apply. Now, you'd still need to go through the designated advisor and consider it's reasonably the best terms that can reasonably be obtained, but you wouldn't need to go through the notice requirement if the charity intends to replace the designated land with other land which is at least as suitable, or the disposition is a lease for 2 years or less, or the Charity Commission's giving you a waiver. In practice, the Charity Commission pretty rarely gives out waivers. It will only do so if it's in the best interest of the charity, and that usually applies if there's already been significant public debate or the matter is really urgent for some important reason. I said earlier that mortgages have a slightly different rule. I'll now tell you about this very similar but slightly different regime. But one point to note is, although the legislation and I talk about mortgages, it's broader than that. These rules probably apply to things like debentures, charging orders, some bank overdrafts, and situations where the loan is to a third party, but the security is given by the charity. So for example, if a trading subsidiary borrowed the money, but the charity gave the security. All of those would fall within the meaning of mortgage. The default rule for mortgages is the same. You can't mortgage charitable land without an order of the court or the commission. Unlike other dispositions, though, you do not automatically need the Charity Commission's consent to borrow from a connected person. But the general fiduciary duties of conflict of interest will apply here and may prevent you doing that anyway. Now, importantly, this is not a once and for all situation. Although you need to go through the process when you take out the mortgage, you also need to go through the process if you borrow further monies or substantively change the terms of the mortgage, for example, a remortgage. So it's not just a one-time deal when you're dealing with mortgages. You might have to do this several times during the lifetime of the mortgage. As with the main default rules, there are exceptions. but fortunately our list is a little shorter this time. You don't need to worry about the default rule for mortgages if the mortgage is authorised by legislation or scheme, or it's made by an insolvency practitioner, or it's authorised by the Secretary of State under the Universities and College Estates Act. But the most important exception is one we've seen before: if the trustees obtain and consider proper written advice from someone who has no interest in the transaction, the default rule doesn't apply and you don't need the consent of the Commission. In practice, this is the rule rather than the exception. So let me talk about the advice that you need to get. The advice must cover 4 things. Firstly, whether the loan is necessary for the charity to do whatever it intends to do. Secondly, are the terms reasonable? Thirdly, can the charity afford to repay the mortgage? And fourthly, if you're securing a non-monetary obligation, let's say a guarantee, is it reasonable for the trustees to be undertaking that obligation? Now, that's quite a different list to the valuation evidence we've had before. It might not be possible for one person to advise you on all 4 of these things. If not, you would probably need to get 2 separate advisors to deal with whichever bits they can. Again, this advice can be provided in-house now, but it's probably only appropriate to do that for low value or simple mortgages. Finally, the Charities Act tells you what must go in most contracts for sales and dispositions. Now, we're running out of time. I know you want to get back to your desks, so I will end with my 5 key tips. I've put the relevant sections on the slide. Technically, there are 2 different groups for mortgages and everything else, but they're materially similar. Second key point, previously, trustees were required to certify the disposition. That's now been replaced with an obligation to include prescribed statements. This basically means wording that's set out in the Land Registry Practice Guide, which you can find online very easily. Thirdly, if the recipient is also a charity, there's some extra material that needs to go in about the receiving charity. Fourthly, a practical point. If you amend a contract for a disposition before the disposition happens, I recommend that you go through the prescribed statements process again. Don't just rely on the first contract, just put it all in the second contract as well, just to be absolutely sure you're covering off what you need to do. And fifthly, if you forget to include the prescribed information, the disposition will still be valid if the recipient acted in good faith. Now, the Charity Commission considers that it will be pretty hard to satisfy the good faith requirement in this context. So in other words, in most cases, if you don't include the right information, the disposition will be void. That once again underscores why it's so important to pay attention to all the rules that I've been talking about this morning. Thank you very much.
Thank you everyone for joining. Our next junior programme will be a webinar about civil fraud and is scheduled for the 3rd of April. Registration will open soon, and please keep a lookout for that. So thank you for joining. Good morning and goodbye from us.
Thank you.